Mr. Jackson, we cannot see you. And I don't know if we can hear you. And I'm sorry, is that counsel for Mr. Jackson or is that Mr. Jackson?
Yeah, I'm not sure.
That's Mr. Jackson. I'm counsel for Mr. Jackson.
All right, well, he needs to watch it on our YouTube link rather than.
Do we have all counsel here?
Did you share with him the link or the login information this morning?
He does have it. Let me tell him to get to the, is the YouTube link in the?
It's accessible through our court's website. Yes.
Okay. All right. Do you mind if I give him a quick call, tell him log off and do the YouTube link?
That's
Go ahead quickly.
yes.
All right.
While you do that, I just want to clarify, is Attorney Keeney joining us this morning?
I
expect her, Your Honor.
I spoke to her on Thursday.
Okay, was she intending to join us then?
Yes.
Okay, do you mind calling her and finding out
No, I don't.
joining us?
I can send her
Waters,
a text message.
we may want to pause the
Yeah, and
YouTube
if
for
you can
a
pause
moment.
the YouTube.
I will.
It seems to show as if it's still recording.
Your Honor, Mr. Jackson has logged off, and I believe he will be
Kathleen, are you
attempting to
going to
find
log on
this,
for
the
all of
YouTube
it?
link.
Kathleen?
My apologies to the.
No, it's on today. Okay, thank you. Bye.
Mark, is the YouTube recording right now?
It is not. It's on pause. I just spoke to Kathleen Kenny. She said she wrote it down on her calendar for tomorrow, but
Okay.
she's logging on now.
That's what I initially had it down on, and then I got called, I think last Friday, and it was scheduled for today. So I'm not sure what happened.
Yes. I think Jen reset it at some point, but she did notify counsel.
Well, considering the confusion, we'll wait for her to link in then.
Okay.
Presuming she'll be doing that very quickly.
She said so.
And counsel, just so you know, we had another case that was to argue before yours, and they have submitted on the briefs. So you'll be the first ones who will be arguing this morning. But the way we're going, it's going to want kind of time-wise about the same, possibly.
So, Your Honor, you're saying there's no pressure on us?
It means you're on standby for a time to be determined.
All right, I see her now.
Okay.
I'll begin the recording.
Good morning.
Mr. Waters, my YouTube now is showing that it's paused on the icons in the top. Earlier, it was showing that it was still recording. You may just want to check that. I think my icon is
I
showing.
think there's
that
a slight delay when I pause and restart, but I have definitely restarted the recording, Your Honor.
All right. The only reason I mentioned that is because the record looked like it just paused, but thank you. Thanks for checking.
All right, thank you. Good morning. Welcome to the First District Court of Appeals. So we have one case this morning, and the case is C-200372 and 376 in Ray BJ. Now we have several attorneys here this morning representing the appellant. We have, I believe, one attorney representing the appellee. So on behalf of the appellant, if each one of you can identify yourself and let me know how many minutes you intend, if you tend to argue this morning, how many minutes, and I also would need to know what you would like to reserve as a unit.
Your Honor, I'm Jeff Kutcher. I represent the mother, Yvonne Jackson. My preliminary question is, will Mr. Sawyer and I, as co-appellants, be limited to the same usual 15 minutes, or will we each have our own time?
You'll be limited, and we didn't talk about this as a panel, but I think that we would be comfortable, I assume, and the other judges cannot, if we gave 20 minutes to each side, so that to ensure that you would have the opportunity to say what you need to say.
Thank you, Your Honor. So I think Mr. Sawyer is positioned to have the primary argument here. As such, I'll ask for 6 minutes and 2 minutes in rebuttal.
Okay, so that's 8 minutes. Attorney Sawyer?
Your Honor, I'm going to go on caution and request 10 minutes with 2 minutes for rebuttal.
Okay. So let's see, because that's 12 and 8 is, there we go. We're good. All right, Attorney Sawyer, whenever you're ready.
Just quick question, Your Honor. How should I go about keeping track of time? I'm used to seeing a red button, green button, card, something along those lines. Should I set a timer on my phone?
You can do that. I'll be keeping track of time and I'll give you a 1 minute warning.
Okay.
Okay?
All right. Thank you, Your Honor. May it please the court. Good morning, Your Honors. My name is Christopher Sawyer, and I'm appearing on behalf of grandfather appellant Joseph Jackson. We respectfully request that this court reverse Judge Powers' grant of permanent custody of Brooklyn Jackson to Hamilton County Jobs and Family Services. The issue in this court is whether it is in Brooklyn's best interest that she be placed with her grandfather, Joseph Jackson. The two factors at issue are legally secure permanences and Mr. Jackson's bond with his granddaughter. Your Honor, it is in the best interest of Brooklyn that she be placed with her grandfather because her grandfather, Mr. Jackson, is able to provide legally secure permanent placement. In N. Ray DM, LW, and LM, the First District Hamilton County Court of Appeals case number Charlie 20043, 2020 Ohio 3273, which was decided on June 10th of 2020, where permanent custody was granted to Hamilton County Jobs and Family Services because mother was using drugs. She was 15 years old at the time. However, mother made progress towards her case plan and obtained employment, housing in Kentucky, stable housing in Kentucky, I should say, and with an ICPC in process. In that case, neither the guardian ad litem nor the Child Protective Services caseworker came to investigate mother's house. This court held that the evidence adduced at trial must demonstrate that permanent custody is the only means by which to provide a legally secure permanent placement, and that the state must prove that the proposed placement is inadequate. Similarly, Mr. Jackson's ICPC has been approved a total of 3 times. The first time it was revoked because of a small issue, but it has since been approved on 2 separate occasions. Just like in NRA-DM, neither the guardian nor the caseworker went to investigate grandfather's home, but are claiming that grandfather is inadequate.
Well, I mean, I guess it's probably unrealistic to expect them to go all the way to Nebraska. What did they take any other measures to try to investigate the adequacy of the home and living arrangements?
Your Honor, per Ms. Kinney's brief, the only investigation that was conducted was a review of the ICPC, which, as I have indicated, has been approved on multiple occasions. But yet the state is still, who has the burden of proof, might I add, is still indicating that grandfather is inadequate.
Now, ultimately, the magistrate did grant the placement for grandfather. Is that correct?
That is correct, Your Honor.
And then it was reversed on objection.
That is correct, Your Honor.
Okay. So, one of the positions that you've taken is a statement that's in the judge's entry to the effect that the magistrate's decision was not in accordance to the law. I'm trying to remember the exact language, but there were 2 positions. One was a statement that was in there about the magistrate's position that was just a general statement. And then the other had to do with the issue of the effect that this would have on the child.
Yes.
And that the mother, whether the grandfather is really would be a good placement because the grandfather also has because some sort of a guardianship over mother of the child and the impact that that might have on the child.
Mm-hmm.
So what is there any evidence to support that from the trial court's position?
To support what, Your Honor? I'm just trying to obtain some clarification.
There was a statement in there with regard to that grandfather had guardianship of child, and the trial court was concerned on grandfather's ability to also be placed, for the child to be placed with grandfather in light of the fact that grandfather had guardianship over his daughter, over the mother.
Yes. So it is true that Mr. Jackson does have legal guardianship over mother. It's over the person, not of the estate. However, at trial, Mr. Jackson did lay out a safety plan of calling 911 and ensuring that Brooklyn is protected from biological mother unless and until there is changes by the court allowing mother to be around her child. Mr. Jackson has indicated that he has notified and he has done this in the past and will not hesitate to do so.
And there was a concern though, because at some time mother was living at grandfather's home.
Correct. When the first ICPC was submitted, Mr. Jackson was ultimately approved at that time. However, it was determined at that time that that Ms. Jackson was living with grandfather for anywhere from 2 weeks to 1 month. She has since obtained stable housing at the Salvation Army shelter in Nebraska, where she is still receiving treatment for her mental health issues. And since then, the ICPC has been resubmitted on 2 separate occasions, and grandfather was approved on both of those occasions.
And when the first ICPC was done, was mother living with grandfather at that time?
I do not know if at that time when Nebraska came to investigate if she was living there or if she subsequently came to stay in between the time of wherever she was living at the time and going to the Salvation Army shelter. That I am not 100% sure of. I came onto the case approximately 4 months after that first ICPC had been submitted and completed.
Okay, thank you.
Your Honor, similarly to NRA-DM, the state has the burden of proving that grandfather is inadequate. The state's argument has been that biological mother could move back in with Mr. Jackson. If we are going to decide this case on what could happen, that will affect not only this case, but also any case pending after that, because that could be used as grounds to grant permanent custody or any single case, neglect and dependency case pending after it.
But isn't this case covered by best interest of the child?
It is covered by best interest, but best interest has to have some sort of grounds for removing the child. What could happen could take us down a very dark rabbit hole of exploring different possibilities where there's no evidence that any of those things could happen. In NRA H&J Children, First District, Hamilton County, Court of Appeals case number Charlie 200-115, 2020, Ohio 3444. Hamilton County Jobs and Family Services removed the children due to substance abuse issues and domestic violence in the home. Grandmother filed an ICPC, which was initially not approved, but then was subsequently approved, and grandmother had only visited with the children on one occasion. This court held that it must be shown that legally secure permanent placement can only be achieved by a grant of permanent custody to Hamilton County Jobs and Family Services. In that case, Hamilton County Jobs and Family Services did receive a grant of permanent custody. Unlike NRA H&J Children, grandfather's ICPC had been submitted and approved on multiple occasions. And although,
just so you know, you have about a minute left.
May I jump in and ask you a question? Do you mind, Mr. Sawyer? You mentioned something a moment ago that caught my attention. You said that the grandfather has to be found to be inadequate. That's not the test, is it, with respect to a non-parent? Does there have to be a finding of inadequacy for the grandfather? Isn't the test what's in the child's best interest?
it is what is in the child's best interest, but the state still has to prove that placement of the child with grandfather is not in the child's best interest.
Agreed, but isn't that a different test than whether he's inadequate? I just wanted to make sure we were talking about the same test and what we are to examine.
It is slightly different, Your Honor, but one and the same. The state still has to show that it's in Brooklyn's best interest that she not be placed with grandfather.
Thank you.
Your Honor, I believe I am out of time at this moment. May I have a brief moment to conclude?
Yes, go ahead.
Your Honor, this court should reverse the trial court's grant of permanent custody to Hamilton County Jobs and Family Services because legally secure permanent placement is available outside of Hamilton County Jobs and Family Services. The state has failed to meet its burden of proving that legally secure permanent placement to Hamilton County Jobs and Family Services is the only course of action that can be taken. Grandfather's ICPC has been approved on multiple occasions, and the state's failure to follow its own rules has prolonged this case and kept grandfather from his granddaughter. Your Honor, for the reasons I have just discussed, we request that this court reverse the court's grant of permanent custody to Hamilton County Jobs and Family Services. Thank you.
Thank you. Attorney Kutcher.
Thank you. May it please the court, opposing counsel. I'm Jeffrey Kutcher, attorney for Mother Yvonne Jackson, and I want to highlight 2 points for the court today. One is that a grant of permanent custody is not necessary to achieve a legally secure placement for this child, Brooklyn. And secondly, and maybe most importantly, the juvenile court's decision is not supported by sufficient evidence. I'll start with the legally secure placement being able to be achieved without a grant of permanent custody. It's our position that the burden is on the state of Ohio to show that the best interest of the child is advanced by an award of permanent custody to the state. We believe that the chief reason that the state is not interested in placement with grandfather is the state's belief that grandfather has conflicting roles when he attempts to serve as legal guardian for his daughter, Yvonne Jackson, the mother of the child, and also the legal custodian of his granddaughter, this very young child.
And that's really the only thing that they focused on, isn't it?
That is my belief in reading the transcripts. The only focus is grandfather is not a good placement, is not appropriate because of these conflicting roles. But as my contracts professor in law school would say, that's just a conclusory statement. It's not supported by anything. There's no evidence that those two roles are conflicting at all.
Well, what is the evidence that was submitting with regard to the role that grandfather plays in that guardianship towards his daughter?
Well, as Mr. Sawyer said, his guardianship over his daughter is that of the person and not that of the estate. I quite frankly don't know the difference and don't know why one or the other, either one of them would be conflicting with being able to be the custodian for his granddaughter. Mr. Jackson was clear that if his daughter, Yvonne Jackson, showed up in such a mental state that she was unstable, that he would call 911, do whatever he needed to do to get her, I think it was to the VA or some mental health board in Nebraska. He would take care of the situation. He's not saying, hey, I can handle them both living here at the same time. He never said that. He showed that protective capacity to take care of his daughter by getting her to some sort of mental health facility as opposed to letting her stay in the home.
And what was the evidence with regard to long-term arrangements, housing arrangements for mother?
I'm sorry, I just got an Adobe pop-up on my screen. I had to pause for a second. May I ask you to repeat that, please?
Sure. What was the evidence with regard to long-term housing arrangements for mother?
I don't recall there being a discussion of long-term housing arrangements for mother. My recollection is simply that of grandfather assuring that if she showed up, he would get her to the VA or some mental health facility. It's my interpretation that
And did the magistrate make any credibility determination regarding that?
I don't recall the magistrate actually in her entry making any sort of credibility call. Although I will point out, as the court well knows, that credibility and demeanor of the witnesses is in the province of the trial court. And absent some showing by a reviewing court, deference should be made to that trial court. So while I don't think the magistrate commented specifically on credibility, I think her decision lets us know that she found Mr. Jackson's testimony in that regard to be credible.
But with that regard, under the juvenile rules on objections, the trial court, which is at that point reviewing the magistrate, gets de novo review on issues of fact in addition to issues of law.
Yes, Your Honor, that's true. And with that, I'd like to put out the lack of sufficiency of evidence. The reviewing court, the trial court, Judge Powers in this instance, I think sought to explain to us why maternal grandfather was not appropriate. And
one of the arguments in the appellant's brief, and I can't recall which one, was that when you look at the magistrate's decision, when you look at the trial court's decision, that it pretty much is the same on everything except for this one determination with regard to a potential conflict of grandfather's role as a guardian to mom, and that conflicting with placement of the of BJ with grandfather.
Your Honor, I believe you're referring to my brief where I point out that I don't think any facts are in dispute at all from the trial that the magistrate heard to the review that the judge did. And again, I think the judge sought to explain why she thought grandfather was inappropriate, but it's a completely incomplete sentence. She says that although mother is not currently residing in maternal grandfather's home, maternal grandfather, and I'm left hanging there. There's not a completion of that thought.
Mhm.
That's the perfect opportunity to tell us why the reviewing court thought maternal grandfather was not appropriate, while the magistrate in that trial thought that he was appropriate.
You're talking about where the juvenile court doesn't finish the sentence at the end of the paragraph?
Yes, Your Honor, I am.
Yeah, okay.
Yeah. Well, the
And-
other thing that I found interesting is in the trial court's decision, and this was the language I was trying to refer to earlier, but I'm going to now refer to its specificity. It says magistrate did not properly determine the factual issues when applying the law, and then goes on later to say the magistrate's decision is not supported by the evidence.
Yes, Your Honor. And so that's
So what do we do with that?
well, I hate to answer with a question. I think what you do with it is you reverse it because it's not supported by sufficient evidence. It seems to be a conclusory statement. It seems to be boilerplate language to say that the magistrate didn't determine the factual issues properly and didn't apply the law properly, and therefore JFS wins. But it's not supported by any sufficient evidence at all.
Okay. You have 1 minute left.
With that, I'll conclude with, as Mr. Sawyer did, asking the court to reverse what turned out to be the juvenile court's final decision in this case. We're asking that the extensions of temporary custody be granted to the point that it wouldn't be moot now, and go back to the magistrate's decision that placement be with the grandfather in Nebraska.
Thank you.
Thank you.
Attorney Miller. And just for clarity, are you the only one that will be arguing on behalf of the appellee?
On behalf of the agency, that's correct. Is the guardian ad litem, is that separate?
We have the GAL for the child here, which is Attorney Keeney.
Would she be, when you ask if I'm the only one arguing for the appellee, do you mean like including her, or would she have separate time? I'm sorry.
Well, that's what I'm trying to understand. Is she,
Okay.
will she be arguing this morning?
Yes, Your Honor, I will be arguing.
Okay.
I would just need about 5 minutes.
Okay. And did you want to reserve any time?
Maybe 2 minutes.
Okay. All righty. So that leaves, Attorney Miller, that leaves you with 13 minutes. How would you like to divide that?
I would like to have 7 minutes and reserve 3, please.
All right. Very good. Attorney Miller, whenever you're ready.
Thank you. And I apologize first for my head being sideways. The webcam only fits right there.
Ms. Miller, can I jump right in and ask you to go to an issue that I'd like you to address? And that is, what evidence in the record would support a conclusion that the grandfather could not provide a safe home for the child?
Yes, Your Honor. I believe, although there is sufficient evidence to prove that he would not provide a safe home for the child, I believe at this time the first issue is that it cannot be done with the timeframes that are available to this court. The test, as you previously stated in your questions to Mr. Sawyer, is not the suitability of grandfather, but the suitability of the parents, and then the best interest of the child. And there's strict timelines that go along with these requirements.
Let's go past the timelines and focus on Judge Meyer's question. What is the issue that shows his inadequacy and that is in the best interest of the child?
Yes, Your Honor. I believe to show his inadequacy at this time, like I was stating before, the law doesn't allow for the child to be placed with him at this time or at the time of the judge's decision. Once a child is placed under an ICPC, even if the guardian ad litem and Job and Family Services had been in agreement with placing the child in grandfather's home at the time that the last ICPC was approved for that placement, there would not be the required 6 months before the child could be placed with grandfather. Therefore, the entire notion of permanency in his home is not possible.
Okay, all right, but again, like the magistrate said, you guys were running out the shot clock. So let's leave the timing issues to the side. We understand those arguments. but specifically, what is wrong with grandfather? Why would he not be a suitable placement?
Yes, Your Honor. In addition to the things noted by the court about him being the guardian for mother and trying to be the guardian for the child, there are additional issues with grandfather's bond to the child.
I'm gonna interrupt you there because I don't want you to gloss over that first point. What specifically is it about being the guardian for two people, the mother and the grandchild, would make him unable to provide a safe environment or an adequate home?
Yes, Your Honor. The fact that he's the guardian for mother is unstable to provide for this child, sorry. All parties have agreed that mother is unsuitable for this child. Mother has severe mental health issues. Mother has never been able to care for this child a day. If grandfather were able to have custody of the child in his home and mother could potentially come there, that would put the child at significant risk. And the test is
I mean, there's no evidence that's ever happened because he never got the opportunity.
Yes, Your Honor. However, the test is asking for best interest of child. It's not asking for his suitability. So rather than if something could happen or whether it would not happen with grandfather, the child currently is in a safe home where they've been since their birth, where there's no possible risk that mother's going to show up and be allowed in the home. There's no history of mother being allowed in the home when the person wanted the child there. The foster home the child's in right now has had her since birth. She's very bonded with the foster home. They're able and willing to provide for her, and there is no possible risk that mother is going to show up and be allowed to live in the home, as grandfather has previously demonstrated to this court that he is willing to do.
What's the evidence that mother actually poses any risk?
That would be her extensive mental health issues and all of the parties agreeing that she is unsuitable to care for the child. Mother has been in inpatient facilities for her mental health.
But isn't there a difference between ability to raise a child and posing risk to a child? Isn't that two different things?
Yes, Your Honor, there is. However, at the initial hearing when the interim temporary custody order was granted, it was proven by the lower court that mother posed an imminent risk to the child if the child was left there. And that risk,
To Judge Zayas's point, it wasn't a risk of violence, wasn't it an inability to care for the child? And if the child is in the custody of somebody who can care for her, if the mother's not at risk of harming the child, or to Judge Zayas's point, aren't those two separate issues?
I would have to find the exact wording in the initial interim temporary custody order that was granted. However, it was proven imminent risk. The standard for an interim order of temporary custody is actual imminent risk to the child, not an inability to care for the child. So at one point when this child was first granted into the interim custody of the agency on June 11th of 2018, it would have been proven by the agency that there was an actual imminent risk of harm to the child if left in mother's care. And since that
Wouldn't
time,
that include something like not caring for the child, not feeding the child, not changing the diaper of the child? I mean, that's different than I guess maybe I'm not asking the question very clearly, but what I'm meaning to ask is there's a difference between harming the child by not being able to take care of the child and harming the child through violence, the latter of which would be a concern if the grandfather allowed the mother near the child. The former wouldn't be, because the mother wouldn't be the caretaker of the child. And I guess I'm asking, is there evidence of the former as opposed to the latter?
Your Honor, it's kind of in between those things. At the initial hearing for the interim custody of the child, it was proven that mother has a history of schizoaffective disorder, bipolar disorder, and MRE mania. Additionally, when she was pregnant with the child before giving birth, she told hospital staff that her stomach was filled with plutonium and that the child was Satan's spawn. Based on those statements is what the court found imminent risk. So rather than just a case of neglect, as in the examples of not feeding or not providing for a child, mother actually was calling the child Satan's spawn and talking about plutonium before giving birth to the child. A lot of these cases are where a child is ready for discharge from the hospital and the hospital doesn't feel a parent can provide, so then they call the agency. In this case, the agency was notified before mother even gave birth due to the extreme level of concerns with her mental health and this child being present around her. There's also evidence that she was supervised the entire time that the baby was even born in a room with mom because of these dangers posed. Which that again brings it to grandfather's willingness to care for this child and keep the child safe. After that ICPC was originally granted, he did allow mother back in his home. And even though he can claim to the court now that he would keep mother away from the child, he has stayed in contact with mother and kept her in his life and been her guardian and allowed her back in the home, where he had only visited this child twice in over a year and a half of its life. There is.
But so are you basically faulting him for trying to maintain a relationship with his daughter?
No, Your Honor. He is not at fault for maintaining that relationship. It would be at fault for choosing that over the best interest of this child.
But what's the evidence that he chose that to the detriment of the child? I guess that's what I'm trying to get at. You can have a relationship with your daughter even if she has, various mental problems and challenges, but that doesn't mean that you're not fully devoted to your grandchild. And I guess that's the disconnect I'm having trouble with.
Yes, that is true that he could maintain that relationship with her and should maintain that relationship with her. However, when he's looking to get this child placed in his home, especially under a document such as the Interstate Compact on the Placement of Children, which has very strict guidelines and was explained to him and was discussed in court, I believe that knowing that he could lose the chance to have this child placed in his home by letting her move back in, he was then therefore taking that interest over the one of the child. His plan now is to send her to one of those organizations to get housing if she ever comes back. He could have done that the first time rather than losing this.
What do we do with the fact that the magistrate seemed to believe him?
Yes, Your Honor. Even if the magistrate believed him, the judge did not, and the judge has.
But the judge didn't see him testify.
That's correct, but the judge did get the transcripts of the proceedings and get all of the evidence that is presented on this from grandfather, and she was able to view the entire docket of records and the entire transcripts from all of the proceedings that have happened before this court. Based on those facts.
So did the judge make any specific finding that the grandfather was not believable or that the child was at risk of harm if being placed in custody of the grandfather?
No, Your Honor. But again, I do not believe the law would require that. We're looking at the best interest of the child, not what's best for grandfather. The best interest of the child has certain factors that are laid out in the statute that must be considered by the court. There are several cases throughout the state of Ohio that have upheld a grant of permanent custody when grandparents have petitioned for custody of this child. Although not by Your Honors, there is a case out of the 11th district in Portage County that does the same of granting permanent custody of a child to the agency rather than grandparents, not based on their unsuitability, but based on the best interest of the actual child. In another case by the 4th district in Perry, the court granted permanent custody of the child after grandparents had an interest based on certain factors that are actually present in this case, such as their lack of visitation throughout the life of the child, lack of contact with the agency, and the child's actual bond in contact with their foster family, which is exactly what we have here. This child has been with this
Attorney
foster
Miller,
family.
unless there's any other questions from the panel, if you'd like to wrap up, and I'll reserve your time.
Thank you. So in sum, this question here is what is in the best interest of the child and not grandfather's suitability. The best interest of the child would be to stay with their foster family where they've been their entire life, where all their needs are provided for, and where they can continue to live their life. The foster family has stated that they want grandfather to be a part of their life and they want him to play the role of a grandfather. That is exactly what he has stated here, is he wants to be a grandfather to the child and continue to be a parent to his child. That's what the foster family would allow, only instead of his daughter raising the child, this family would raise the child. And from the agency's perspective, this is what's in the best interest of the child.
Thank you. Good morning, Attorney Keeney.
Good morning, Your Honor. May it please the court. Good
And we're
morning.
glad that you were able to join us this morning.
My apologies.
No, you don't need- I understand there was some sort of confusion because
Yeah,
that
very much apologize.
You're fine.
The guardian ad litem would ask the court to finding that permanent custody would be in the best interest of the child. I think it's important not to gloss over the other factors in this case, as no greater weight is held on each specific factor. Each factor has an equal amount of weight as the court determines what would be in the best interest of the child.
And that, I mean, the case law has said that we really leave it up to the trial court to weigh that and to determine, you know, if there's any factors that they're going to give more weight or how they're going to weigh it.
Okay.
So you're right. I mean, there's no, there's no presumption that any factor has more weight, and we base and we give deference to the trial court in the weighing.
Okay. So first I want to touch on the interrelationship of the child with the individuals in their life. The child is very bonded to the foster parents in this home. I apologize. I think if you guys can hear, my neighbor's dog is barking apparently.
Yeah. And I believe that finding of fact was determined and has not been challenged.
Yes. But I do think that it does have some weight in this case here, something that should be considered as we go through these best interest factors. The wishes of the child, the guardian ad litem, the previous guardian ad litem on this case had determined that permanent custody would be in the best interest of the child. Now, concerning the issue that we are facing here today, concerning the grandfather having guardianship over mother and the child, the testimony from the previous caseworker indicates that at one point, Mr. Jackson had said that he hoped that the child would come to his home so that he could be close to Miss Jackson, as Miss Jackson was in Ohio. So it appears that through the court's review of the record and the transcripts of the case, that this is another factor that the court could have looked at, could have seen, that the grandfather wanted the child to come to the home in Nebraska with him so that he would be closer, or that Miss Jackson would have a reason to come down to Nebraska and be closer to him and the child. That particularly has some weight, considering whether or not it would be in the child's best interest for that. Also, the grandfather has emphasized that he does have a safety plan for if the mother were to come to the home. However, the court, based on the transcripts, the court
But this is my problem. I mean, you're saying based on the transcript, and the magistrate was the one who was evaluating the witnesses live, not looking at a transcript. And I guess that's part of my concern is, you know, we see these cases all the time, and it seems like, you know, in a lot of cases, the juvenile courts are deferring to the magistrate, but in other times they're not, but there's no explanation often as to why we are rejecting the magistrate's factual findings.
Yes, Your Honor, and I understand in this particular case as well, the judge's entry did not explain her concern, particularly with paternal grandfather's legal guardianship over
so what
mother.
are we supposed to do with that?
Well, Your Honor, I think that because the trial court has the ability to do an independent review and review that evidence and review that record, I believe that it does have some basis for a finding of that, as they are to go through all the evidence that's presented. And yes, they weren't there at the time when testimony was occurring, but they did have the opportunity to do an independent review based on the transcript, based on the evidence, and based on the written arguments that were presented to the court. And paternal grandfather's attorney had also mentioned that he was under the impression that the agency and the guardian ad litem had not investigated paternal grandfather's home. However, based on the ICPC, the receiving state will determine whether or not the home is safe for the child, and that is laid out in the Ohio Administrative Code 5101. So based on their determination, they can use that finding to determine whether or not it would be a placement, a good placement for the child. The ICPC was initially approved. However, once they found out that grandfather had allowed mother to come back into the home, the ICPC was denied. This causes some concern. This did cause some concern for the agency that was testified to and also found in the transcripts as to why the father let mother back into the home, causing us somewhat of a safety risk for the child. That father, after the ICPC was approved, then allowed mother back into the home, which then led to a denied ICPC based on that fact alone. So given the fact that the relationship, not only did grandfather mention to the previous caseworker that he hoped that bringing the child down to Nebraska would also bring mother down to Nebraska. It seems that there is an alternative reason for why grandfather is agreeing to care for the child. The court could determine that based on that statement to the previous caseworker, coupled with the fact that the child has a significant bond with the foster family. I think it's very important for the court to recognize that grandfather did not visit this child in the time period that we were going through the court proceedings. Grandfather only visited the child twice. He had multiple opportunities. He had opportunities to reach out to the agency. He had opportunities to reach out to the foster parents to create a time where he could visit with the child. However, he did not visit with the child.
An attorney,
That-
1 minute.
Thank you, Your Honor. That lack of forming a relationship, coupled with the relationship that grandfather continues to have with grandmother, and the concerns of his reasoning behind wanting to take custody of the child, gives significant evidence, sufficient evidence to determine that permanent custody would be in the child's best interest. Therefore, the guardian ad litem, based on the evidence provided and the decisions of the court, would ask that this court affirm the trial court's entry of permanent custody being granted to the agency.
Thank you.
May I ask Ms. Kenny one question before she leaves? Ms. Kenny, let's assume that we disagreed with your arguments and that the evidence did not support a finding that permanent custody was the best interest of the child. In light of all the timing issues, what would be the remedy?
Your Honor, I suppose that alternatively, a grant for the first and second extension would be the alternative path, although we do run into those timing issues. However, I believe that would be the alternative, would be a grant for the first second extension to determine whether or not we can place the child with grandfather in Nebraska and move forward with that.
But one follow-up to that, didn't the magistrate already determine that the child could be placed in Nebraska and should be placed in Nebraska with the grandfather? And then,
Yes,
so
sure.
do we does anybody have to look at that again?
Your Honor, there has been some time that has lapsed since grandfather, since the magistrate's entry. So I do believe that it would have to be revisited. And the ICPC, we would have to see if the ICPC is still current before moving the child, and see if there's an approved ICPC before moving the child at this time.
Thank you.
Thank you.
Attorney Sawyer?
Very briefly, Your Honor.
And I'd like for you to address something that Attorney Keeney brought up. And she was highlighting some of the other factors, specifically, there is a clear determination on the bond that the child has with the foster parents, and how, what a wonderful job the foster parents have done, and their willingness to adopt a child. So keeping in mind that, the trial court gets to weigh the best interest factors, right? How would you respond to, well, maybe the trial court just weighed that one heavier and decided that that was a basis for reversing the magistrate?
So the bond that this child has formed with the foster family is through no fault of grandfather's. This child is 2 years old, approaching 3 this year. So she will have some sort of a bond, but she was never given the opportunity to develop a bond with Mr. Jackson. He does not have that opportunity because the state has refused to place the child with Mr. Jackson. Your Honor, if I may address one of the questions that Judge Zayas brought up to, I believe, Mr. Kutcher regarding mother's long-term housing arrangements. There was an exhibit submitted at trial showing a lease that she has through the Salvation Army in Nebraska, where she is still residing to this day. To address some of the other issues, specifically regarding visitation with Brooklyn, one thing that is not being taken into consideration is that Mr. Jackson lost his job as a result of driving from Omaha, Nebraska to Cincinnati, Ohio on multiple occasions to attend court hearings. Now, he has since obtained new employment, and as this court saw in the beginning, Mr. Jackson was on the phone for this Zoom hearing. Mr. Jackson has been involved since the beginning in attempting to obtain custody of his granddaughter. The ICPC has still been approved multiple times, even after the first revocation. And the Guardian is indicating that reviewing that ICPC is still an adequate investigation, which has approved grandfather, but they're still claiming that placement should not be with grandfather. Lastly, Your Honor, as I indicated previously, the state's argument is that mother could show up. A lot of things could happen. Mother could show up, she could never show up. We simply don't know, and grandfather has not been given that opportunity to develop his bond and show that he can keep his granddaughter safe from biological mother. With that being said, Your Honor, we would respectfully request that this court reverse Judge Powers' grant of permanent custody to Hamilton County Jobs and Family Services and grant an extension of permanent custody. I'm sorry, of temporary custody, my apologies, temporary custody. Thank you, Your Honor.
Attorney Kutcher?
Thank you, Judge Zayas. And to respond to your comment regarding the bond of the foster family, yes, that's not challenged. This is a newborn child who went into the care of this foster family. So of course the child's going to be bonded to that family. And if the child wasn't bonded to that family, JFS likely would have moved that child to another foster home where that child would have bonded with that family. And so all of this is in the control of JFS, not at the fault or to the detriment of the grandfather. The grandfather, remember, has 3 different approved ICPCs. And to be most accurate, I guess it's 2 ICPCs, but then Yvonne Jackson was living with him for a couple weeks, and so there was a question and it had to get reapproved. So maybe that first one got approved 2 different times. But theoretically, on each instance that ICPC was approved, here's a grandfather in Nebraska saying, okay, I'm appropriate, let me have my granddaughter. And so the bond would have been formed with what is the adverse party? The grandfather. Remember, the grandfather is the adverse party to JFS. And so when we're talking about a newborn, I think that newborn's going to bond with whomever is taking good care of that newborn. And there's no evidence the grandfather would not have taken good care of that newborn. Let's remember this too. Testimony was presented that grandfather has a 17-year-old child he is raising who is excelling in Nebraska. The evidence presented is that child is in a program earning college credits while he finishes high school. And I think in total, the evidence presented was that grandfather has raised 3 children, one of them being the mother, Yvonne Jackson, who he didn't give up on just because she has mental health problems. Wouldn't it be the situation that JFS would hold against grandfather the fact that he left his daughter Yvonne Jackson with mental problems out on the street or somewhere? That wouldn't show any protective capacity at all, or any nurturing or anything like that. So let's not hold against grandfather that he's the legal guardian for his own daughter, and he's making sure her needs are met without any conflict shown to the court that he would not be able to also be the custodian for his granddaughter. In summing up, it's our belief that the state had the burden. The state was required to show by not only clear and convincing evidence, but also by sufficient evidence that the best interest of this child would be advanced by a grant of permanent custody to the agency. It appears obvious that the magistrate in the trial court found the factor under 2151,
Attorney Kutcher, if you
414.
want to go ahead and wrap up, please.
Yes, D1D, that the child's need for a legally secure placement can be achieved without a grant of permanent custody to the agency. With that, we'll ask the court to reverse the juvenile court's final decision and make whatever orders it needs to make to place this child with the grandfather. Thank you.
Thank you. And if there are no further questions from the panel? Okay. Thank you for everyone's arguments this morning. We will take the matter under submission and issue a timely decision, and have a wonderful afternoon.
Thank you.
Thank you.
Thank you, Your Honor.